judicial review. That is what we need to work and find solution to achieve together all these problems. But I don't want to talk more in this moment about. I want to open a discussion with the assistant who wants make comments or remarks. Do we have a mobile microphone here, please?
Thank you very much. Hert Vermeulen, Belgian DPA. I thank the panelists, especially Paul, for opening up to criminal law cooperation. I think it's very much correct to keep in mind that enforcement under domestic legislation, even if regulated in a future regulation, will still be eligible for criminal law sanctioning as well in member states. And I think, frankly, I don't have like the master solution, but very many of the issues that have arisen in the entire debates are very old issues that have been dealt with in the context of EU criminal cooperation for a long time. The entire discussion about the choice of the forum, if I can refer to Henri Dondieu de Vabre and his famous book of 1928, he already came to the conclusion that exclusive choices for a given criterion as the sole criterion and the lead criterion will always fail when you work with different member states. So it ought not to be per se the state where you're registered or the state where the victim or the complainant is. We may have various complainants from various member states, so proximity will not be realized in all circumstances. So you need a flexible set of acceptable criteria. This is the outcome of the entire process, for instance, in the context of discussion about the forum choice in which Eurojust plays a key role. And we still don't have the solution there at EU level, even if we're thinking about it for the past 20 years, but there's very interesting and relevant and useful ideas. Probably a mechanism like Eurojust is something like between the black and white solution of like a lead DPA on the one hand or a supranational body on the other hand. It's like quite flexible, quite pragmatic, sort of intergovernmental gathering of different liaisons who sit together and discuss things as equals. It's probably a nice in-between for a certain phase, and maybe later on, like we have discussions with EPPO, it will eventually grow into something bigger with supranational characteristics. So I think there's so many lessons to be learned from these other spheres that they can be very helpful in the debates. Linking it up and providing links between such a mechanism and Europol and Eurojust seems quite important as well. Eurojust can deal with data protection cases for the member states where there's criminal law sanctioning. It has a proper case management system. Europol can do the same and come up with intelligence. There is even a Europol cybercrime center located there. So I think keeping in mind that a good link between data systems of these bodies and a future mechanism in the sphere of data protection is quite relevant as well.
Thank you. I have another question over there. Maybe we can take both together and after that if you want. No, okay. Please.
Okay, thank you, Chairman. Willem de Beukelaar from the Belgian Data Protection Authority. Two small ideas. First of all, I think we have already a one-stop shop. It's maybe not a shop, but more a jurisdiction. But after the ruling of the European Court of Justice, the 13th of May, we all, well, should be aware of the power of the European Court of Justice. And I think that it is unavoidable, even if we have a new system, that the last word shall be said by this European Court of Justice. Because why try to find a new system when we have already one? Maybe it should be better performed, but I don't think that we can, let alone the whole system, the normal judicial system that we have already in place. A second idea, where is the citizen in this whole story? Where is the data subject, already once again a subject? We have in the new proposal a fantastic good principle, the targeting principle. Well, this targeting principle can maybe also a leading principle for not only cooperation but also for the dedication of this data protection authority that should be in charge. And that should be also compliant with Article 13 of the European Convention of Human Rights, who give the right to every citizen to go to the courts of his own country and his own jurisdictions. Thank you.
Thank you, William. Any other comment or suggestion? I can see the... Okay.
Hi, I'm Marty Abrams. I am not European. I lead the Information Accountability Foundation, and also rapporteur for the conference itself. And I would like to see if we can link this discussion to the morning discussions on interoperability and the need to have some level of trust and trust and cooperation and mechanisms in a global world where data just doesn't stay static one place, but data moves other places, and the need to overcome some issues to get there. I was just wondering, in this global world where I work a great deal, much of the question goes to the resourcing of agencies that you need to trust, and based on the resourcing, them having the skill sets to do what Paul was discussing, which is negotiating with organizations about very complex concepts and coming to the right decision at the end of those negotiations. So I'm just wondering from this wonderful panel if you could discuss this question of trust based on equality of resources and how much of these issues relate to that question.
Thank you, Martin. There was another one. Yes, please.
Hi, Pat Walsh, José. It relates to Paul's discussion of harmonisation and partly relates to Marty's intervention, which is, of course, that despite perhaps having one regulation, we will still have 27 various flavours of the e-privacy directive. Article 89 seeks to address that. And to take Marty's point, how will you achieve interoperability and cooperation between the telco regulators? Because it is not the case that DPAs have responsibility for the e-privacy directive in every single country, for example.
Thank you. Everyone wants to comment on this?
Can I comment on? I had a couple of thoughts on the very first, just trying to bring together the first points, the proximity. The proposal by the Commission, which has been around for 2.5 years already, deals with this. There are, from memory, 2 articles, I think it's Articles 73 and 75, that deal with the fact that a data subject can lodge a complaint with the local data protection authority. So no matter what, and I think this is right, the individual has to have the ability to seek the comfort and the help of the local data protection authority. And no one, I think, has ever questioned that. And I don't think the Parliament or the Council will change that. Addressing the other point about the judicial remedy, which I think is a very important legal point. Again, I think Article 75, I think it is, has a provision there whereby, again, an individual data subject has a right to lodge or to start legal proceedings both in the jurisdiction of the data controller, but also in the place of residence of that individual data subject. So I think both those elements of the ability to lodge a complaint with a local authority and the ability to go to court locally, I think are compatible with the oversight of a competent data protection authority somewhere else. Legally, I think that can be achieved.
You have right. The individual can lodge a complaint by the local, the national authority of his residence, but if this authority is not competent, can only be post office, like I said, and send the compliance to the competent authority, that is the main establishment, the authority of the main establishment. And when this authority make a resolution, if the individual don't agree, this resolution from an authority of other country cannot be challenged before the courts in his national state. That is what I mean. There are also very relevant problems with the judicial review. It's true, the individual can go direct to the national courts and not go to the data authorities. But in this case, it would be more parallel processes. And as I tried to say it could be that the decisions are more different than now. We can achieve the opposite. But we have to finish before. I want to say. I would say we need simplification and we need more consistency. But simplification and consistency cannot be achieved at the cost of the effectiveness of the protection of the individual rights. It is necessary to find a fair balance. It's necessary to find a fair balance between both. And the Parliament, the Council of Europe, the Commission, and all the data protection community in Europe, we are working in this direction to find a fair balance. And I am sure we will be successful. Thanks a lot to the panelists, thanks to the assistants, and many thanks to Deisha Madhub and his staff for organizing this great conference. Thank you very much.
Thank you for the panelists of panel 1. Thank you. Just a reminder that panel 4 discussion is going on in the Barracuda room upstairs, and that's regulators' do's and musts for effective enforcement. Right now, we've got panel 3, topic surveillance versus dataveillance, and I invite Jan Albrecht of the European Parliament, David Medin, Chairman of the Privacy and Civil Liberties Oversight Board, Paul Nemitz, Director, Fundamental